it's very important from a historical perspective. Sheikh Abdullah refers to the land reforms which were taking place post the First Amendment and the other amendments which took place to the Constitution. He says Pakistan, on the other hand, is a feudal state.
That's correct.
And therefore, our interests would not be protected in a feudal Pakistan as compared to an India where land reforms were taking place. Then he refers to the fact that, India has, of course, the access to the seas and therefore a better, as an economic powerhouse for us to carry on trade through the auspices of India.
But all that is very important. The reason is simple. Ultimately, what did J&K do? The people of J&K gave to themselves the constitution just as the people of India gave to ourselves this constitution. So central to all this is the will of the people. And therefore, you'll have to compare it to the...
Very interestingly, see how Sheikh Abdullah puts it. He says the most powerful argument which can be advanced in her favor is that Pakistan is a Muslim state.
Yes.
And a big majority of our people being Muslim, the state must succeed to Pakistan. But then he says, this claim of being a Muslim state is, of course, only a camouflage. It is a screen to dupe the common man so that he may not see clearly that Pakistan is a feudal state in which a clique is trying by these methods to maintain itself in power.
Absolutely. He is right. The point I'm making, Mullahs, ultimately, what's the essence in this matter that your lordships are hearing? The will of the people of a state where the Executive Act of the Union of India, which decimates the will of the people. That's the issue before you. That's what your lordship, because all the three acts of the Union of India are executive acts. 356 deletes the proviso of Article 3. That's an executive act.
Mr. Sibal, look at the foresight of the speaker. He says, these days, economic interests and a community of political ideals more appropriately influence the policies of state.
Absolutely, absolutely.
He had this vision in 1951 when he was speaking about the importance of economic interest, which is what the world is talking about today.
Absolutely.
In a globalized world.
And in that situation, the ruler had no choice. Absolutely no choice. So, Manoj, the point I was making is that we are now dealing with three executive acts. One, the 356. Two, change of interpretation in the definition of Constituent Assembly under 367(1) and the abrogation. These are all executive acts. The will of the people is not considered at all. That's the question. Can you delete provisions of the Constitution by an executive act? Can you decimate the Constitution by an executive act? Can you change the Constitution by an executive act? We're not talking about legislation here. We're not talking about parliamentary legislation. That comes after these executive acts, Mullahs, are implemented. That's the question. You can't change the Constitution of India as applicable to Jammu and Kashmir by deleting Article 3, the proviso to Article 3. You can't do that through an executive act. You can't change the definition, Mullahs, of the Constituent Assembly as legislative assembly through an executive act. And this is exactly what I've been submitting before your lordships. A unilateral executive decision cannot change the terms of a relationship which are constitutionally embedded in Article 370.
Formulate, now that we've seen the speeches, we'd like to formulate the principle which
the principle is, Mullahs, that an executive act of the Union of India cannot alter unilaterally provisions of the Constitution of India as applicable to the state of Jammu and Kashmir. That's the central...
Cannot alter unilaterally
the
provisions of the Constitution
of India as applicable to the Jammu and Kashmir, including getting rid of the special status given, acceded to by the government of India and by Parliament in enacting 370 of the Constitution. That's the submission.
Say it's an executive act.
I'll say 356 is executive, 367 definition is executive. These are all executive acts. Parliament came into the picture when the changes had already been done through executive acts. We're challenging that.
As you argued, the process was wrong.
Yes.
Whatever was done.
Yes.
That is, the Parliament did it.
No, Parliament accorded approval to the executive acts which unilaterally changed the Constitution as it was applicable to the state of Jammu and Kashmir. That's the central question that your lordships will have to decide. Could Parliament could the Union of India have done it?
So is it your case that the Parliament could have done it?
No, not at all. Mullahs, that also I will answer. Mullahs, kindly see. ultimately, this was a political decision taken in the context of the situation then prevailing, right? And the complete abrogation of Article 370 must also be a political decision. Whereas your lordships will remember Brexit, what happened? In Brexit, what happened? There was no constitutional provision seeking a referendum. But when you want to sever a relationship which has been entered into, you must ultimately seek the opinion of the people. Because people are central to this decision, not the Union of India. It goes counter to the very grain of Article 370.
Mr. Sibal, in a constitutional democracy, seeking the opinion of the people has to be through established institutions.
Agree?
Right? So long as a democracy exists, as it does, in terms of a constitutional democracy, any recourse to the will of the people has to be expressed and sought in terms of established institutions.
I agree. So either you do it,
you cannot envisage, therefore, a situation like a Brexit type referendum.
Yeah.
That's a political decision which was taken by the then government.
Yes.
But within a constitution like ours, there's no question of a referendum.
But this is a political decision that they have taken by unilaterally through an executive order, changing definitions. This is not some constitutional decision. That's what your lordships, supposing your lordships were to say that they can change the definition, or your lordships were to say.
But therefore, the ultimate question is whether the constitution does or does not interest that authority.
That's correct. That's all that I'm asking, Miller. I'm not asking for anything more.
And which in turn depends on whether 370 is construed as you say, a permanent feature, irrespective of the terminology used, because that is in the context of the changes till the Constituent Assembly was there, or is it something which is capable of being?
Well, let me see. That's a much higher level, Malas, to which I'm not, in fact, arguing that today. Malas, whether it is permanent or it is temporary, let's forget about it. The central question is, can the Union of India, in this manner, terminate that relationship that is constitutionally recognized in Article 370?
You understand?
It may not be permanent. It may be permanent. It may not be. You may change it. You may.
I said in the context that that was the argument earlier. So we have come to the next argument, which is the manner in which it is done.
That's right.
Is flawed according.
It's absolute. It's a fraud on the Constitution itself, according to me. It is politically motivated. It is a political act. These executive orders are political acts. They are not constitutional acts. That's my submission. And whether it is a permanent feature or a temporary feature is really at the moment not an issue. The reason why it's not an issue is maybe there is a constitutional way of doing this. I'm not addressing that, nor have they resorted to that constitutional methodology. If they resort to it, it will be tested in a court.
And on the process, you said last time that, first, the Section 92 power was vested in the governor, independent of the Council of Ministers. Step
36, 38.
Right. Step two, the Legislative Assembly is dissolved by the governor under Section 53 without aid and advice.
Yes.
3, the proclamation is issued under Article 356.
Yes.
You said that the object of the proclamation under 356 to eventually restore democracy.
That's right.
And not the decimation of democracy.
Right.
And then finally, we saw the amendment of Article 3 in the presidential notification.
That's right. That's also an executive act.
All these 4 steps, according to you, were constitutionally flawed. There was no provision for these 4 steps because you've essentially taken away the powers of the State Assembly and exercised them under the garb of 356. That's the submission.
That's right. Absolutely, I'm deeply obliged to your lordship. But I just want to read one other.
Only one last thing which I wanted to ask you. You made your point on the process which was followed. They will have to answer it. On the proviso to clause 3 of 370, is there something ultimately that happened in the Constituent Assembly which sheds light on which way the Constituent Assembly was inclined to go?
Yes.
Because we are reading individual speeches. What happens thereafter at the end of this process in 1957?
The Constitution was adopted in 1957.
Yes.
By the legislature of Jammu and Kashmir. Between 1951 and 1957, they could have determined or terminated the essence of Article 370, abrogated it themselves and said, there's no need for this Constitution. We want to be a state, the part of India, like any other state. That is why 370 sub-article 3 referred to the decision of the Constituent Assembly. That decision could have been taken. But my lord asked me the question, well, now that there is no Constituent Assembly, how will this happen? If it were deemed to be a temporary provision. That's what my lord put to me. Right?
So your argument would be really, I mean, if I can put it that way, that the proceedings in the Constituent Assembly of the state of Jammu and Kashmir would indicate a reaffirmation of the arrangement under Article 370 as a long-term arrangement.
That's right.
So that the three options that Sheikh Abdullah spoke about, namely either of joining Pakistan, acceding to India, or remaining independent, they gave up the first and the third option.
That's correct.
They decide that the ultimate decision was to stay within the dominion of India, but subject to the safeguards of 370.
That's right.
And therefore, according to you, 370 assumes a permanent character, irrespective of the nature of the provision which is envisaged in the Indian Constitution.
And that's what Sheikh Abdullah said in his speech, that look, this relation...
That still begs one question as to whether it was enough that the Jammu and Kashmir Constituent Assembly proceeded on that basis. Could 370, which was envisaged to be a temporary provision, be converted into a permanent provision merely by the proceedings of the J&K Assembly? Or was there some further act required from the Indian Constitution, either in the form of a constitutional amendment, by virtue of which 370 would cease to have a temporary character but have a permanent character, in implementation of the wishes of the Jammu and Kashmir Constituent Assembly?
Whereas Government of India never expressed a contrary opinion throughout.
But didn't it have to take place through a process of amending the Indian Constitution itself?
No.
To convert the character of 370?
All right. Now your lordships are again going back on the issue of temporary nature. That temporary nature is not part of the Article 370. It's not part of it. It's not a part of 370, Madad. In fact, Muzaffar Beg says we didn't even know about it. That's why I want to read Muzaffar.
Mr. Sibal, there are two ways that we could really lead into this discussion. One, that though placed in Part 21, Article 370 was never intended to be a temporary provision. That's one layer of reasoning, which is what you're advancing. Two, that though it was temporary, the reason why it was placed in a temporary provision of the Constitution was pending the decision of the Constituent Assembly of Jammu and Kashmir, and therefore it was given the character of a temporary provision, because the views of the Constituent Assembly of J&K were still to be elicited.
Right.
Third, that's the second argument. We accept that for the purpose of hypothesis. The difficulty, of course, which we have to face is this. Assuming that was why it was placed as a temporary provision, because the views of the J&K Constituent Assembly were still to be elicited. And we also take your point that the J&K Constituent Assembly decided to accede to India and reaffirm the accession to India subject to the safeguards of Article 370. Is that sufficient in itself to convert 370 into an unamendable or untouchable provision?
Let me assume, Malaj, that it is not.
Or was something more required by a parliamentary intervention in India post-independence to convert that which was essentially temporary into a permanent provision?
Let's assume, Malaj, that it is amendable for the sake of argument. Then, Malaj, how is to be amended? The Constitution must provide a solution, no, Malaj? I'll assume, Malaj, for the moment that it is amendable. Then how does the Constitution of India must provide a solution for that?